Hello, everyone, and welcome to our webinar. My name is Elina Santana, and I'm an immigration attorney. Thank you so much for joining us today. I apologize, we ran a couple of minutes late. We were having some technical difficulties with the link that was sent out to all of you. I want to start by telling you something that may surprise you. Most of the people who come to my office, people just like you, waited years before picking up the phone. Not because they didn't have options, but because no one really told them that they did. So, what do we do? Who am I? And why are you here listening to me? I am physically sitting in the moment in Miami, Florida. That's where our office is based, but we actually do practice nationwide all over the United States and abroad. I'm originally from Miami, born and raised, Cuban American, daughter of immigrants, and I've spent my career doing exactly one thing. That's helping families navigate a system that was really not designed to be easy for them. My firm, Santana Residency Law, you can see the name here and the number, handles a full spectrum of immigration cases, from families trying to bring in a spouse or a parent home to individuals facing deportation who feel like they've already lost. We do marriage-based residency and fiance visas. We handle removal defense, which means we fight for people that are in immigration proceedings and in immigration court, people who have received a notice to appear or already have an order against them sometimes. We file waivers, known in Spanish as perdones, for people who were told they have a bar or a mark on their record or unlawful presence that's blocking them from a path forward. We represent asylum seekers who are fleeing and trying to get humanitarian relief in the US. And when cases need to go further to federal court or circuit court, we go there too. I'm personally licensed in Florida, in the Southern District of Florida, and the 11th Circuit Court of Appeals. And we have a whole team. I have other attorneys here too that are licensed in several other places. I sit on the National Board of Governors for the American Immigration Lawyers Association, and I've been called on by many, many news outlets, Univision, Telemundo, NBC, NPR, to explain immigration law to the public because this work matters beyond the courtroom. Whatever brought you here today, there's a very good chance we've probably handled a case like yours. But none of it matters. At the end of the day, who I am and what I do really doesn't matter. What matters is that I've sat across from families in crisis and found solutions, which is what people come to me for. So today's webinar is not a sales pitch. It's all about information. I want to give you real, honest, and practical information. It was marketed as a Q&A, and that's exactly what it is. I'm here to answer your questions. As you saw in some of the emails that went out, we did tell people to go ahead and write in their questions if they already knew what they were. So we already have a huge list of questions. And so I have these over here, so don't mind me if you hear my keyboard as I go through them. But you will also notice at the bottom of your screen a little button says Q&A. You can click that Q&A button and you can submit a question. You can do so anonymously if you wish. And my job right now for the next 51 minutes is to answer them. If at the end you feel like your solution needs a closer look, I've actually set a special offer aside for everyone watching today to get a discount on our consultation. So stay tuned to the end, and I'll share that information with you as well. So don't forget, use that Q&A button on the bottom. I will also remind everyone that we are speaking in English now from 6 to 7 p.m. Eastern Time, and I will actually be on for another hour from 7 to 8 p.m. Eastern Time, and we will be doing it all again in Spanish. We may have some of the same questions because some of them were written in, but we'll also be taking live questions just like we're doing right now. So if you have anyone you want to join in Spanish, or if you prefer Spanish, you can stick around and do that from 7 to 8. And with that, let's get to it. Again, don't forget that Q&A button in the bottom, and we'll start right away with the first question. And the first question we received was, why do I need a lawyer? Can't I just do this myself? I've seen that the forms are online, and it seems like I can do this. So let's talk about that. Yes, the forms are online. They are all public. USCIS has designed them to look approachable, and that's intentional. In my opinion, it's a trap. Immigration law is not just forms. We don't get paid in our office to just fill out forms. That's part of what we do, but that's really not what our service is about. It's knowing which forms, what conjunction of forms, when to file those forms, strategically speaking, in what order to file those forms, what to file with those forms, what to say in the forms, what not to say in the forms, and really which boxes to check. And that's the most important thing. A wrong answer in immigration form can bar you for a very long time. And I don't say that to scare you, but I have seen it many, many times where people will check the wrong box. And similar to a tax return, right? It can have some really big consequences if you don't know what you're doing. A missed question can similarly trigger flags, fraud flags. A question that you don't answer fully can definitely trigger fraud flags. And so we fix do-it-yourself cases every week. Unfortunately, we have many clients that come into this office that have tried to do something on their own, and now we're in cleanup mode. And frankly, it's significantly harder. It's more expensive, it's higher stakes, and it's much easier to get it done right the first time than it is to fix it. So, can you do your own immigration paperwork? Absolutely. That is absolutely something you can do. Would you do surgery on yourself? Probably not. Could you do surgery on yourself? You could, but it's probably a bad idea to watch a YouTube video and try. So it's basically the same idea. It's really what our consultations are for, so you know what you're facing and what you can and can't do. So let's see, more questions. Our second question that we received here was, what is the difference between a green card and citizenship? Okay, so a green card, which is actually called lawful permanent residence. And fun fact, green cards are greenish now again, but for a long time they weren't even green, and we kept calling them green cards. Nevertheless, a green card, which is a lawful permanent residence card, it gives you the right to live in the US permanently, we'll say, but it doesn't make you a citizen. As a green card holder, you can travel, you can work, you can sponsor certain family members, you can build your life here, but you cannot vote, you cannot hold certain government positions, and your status can be taken away. So even though we say it's permanent because it's renewable, it can be taken away under certain circumstances. And usually that means criminal convictions, it means you spending too much time outside of the US, and several other things that exist. For the most part, it is very common that we defend people that uh, try to do this by themselves and often don't declare their criminal records or don't submit the right paperwork. So it's really important that you get a consultation if you do have a criminal record, just side note. Let's go back to the question. What's the difference between a green card and citizenship? Citizenship is really, we call it naturalization, and that's the application that's the final step. It's what gives you a US passport, it gives you a certificate of citizenship, gives you the right to vote, and it's essentially can't be taken away from you. There are very limited exceptions, generally related to if you committed fraud to get it, but as long as you didn't, generally the exceptions are quite limited and your citizenship is permanent. Most green card holders can apply for naturalization after 5 years as a permanent resident. If you got your green card through marriage to a US citizen and remain married to that US citizen, then you can often apply after 3 years. So there are some exceptions there too to the time period. Do you have to apply at the end of 5 years? No. There are many people who wait many years to apply for their naturalization. Should you? Probably not. The sooner you become a citizen, the more protected you are and the more permanent your status. So I don't recommend waiting, but can you wait? You can. Um, People often wait too long, in my opinion, to naturalize. And if you're eligible to naturalize, there's really very little reason to delay it. Citizenship is the most protected immigration status that exists. And if you already have a green card and you're eligible to naturalize, that's one of the best moves you can make. And you definitely should talk to an attorney about getting that done. I have a question that came in here. If I can't afford an attorney, can I go to a certified forms preparer? So that's interesting. The word certified there is really interesting. Um, there really isn't such a thing as certified form preparer. At least in South Florida, they're usually called notarios. There are DOJ accredited reps. DOJ accredited reps are people who are actually accredited by the Department of Justice and have been given permission to have some limited amount of help they can offer. But if you are not talking to an attorney, you are not talking to anyone who is licensed to practice law. Generally, it's someone who cannot give you legal advice. So, can you go get your forms filled out by someone? Sure, but they are not allowed to give you legal advice. They are not allowed to advise you as to what forms you should be filing, what you should be putting on those forms. They're literally only allowed to fill out the form that you walk in and say, this is what I want to fill out. Now, On a practical level, that's not generally what we see at forms preparers' offices. And there are some legitimate form preparers that do follow the law, but unfortunately, there's a lot of them who don't. And so, all I will say is be very careful when you're dealing with someone who isn't an attorney, that they understand their role and they do have an important role. But the legal advice of what you should file, who qualifies, and all that, at the end of the day, you should be getting from an attorney. If something goes wrong with your paperwork, an attorney like me has their license on the line. We've given you legal advice. We could lose our license for committing fraud or, you know, actually doing something wrong on the legal sense. Other people who don't have a license can't. And actually, in some places, they're not even allowed to practice. As a matter of fact, where I am in Miami-Dade County, there's actually local county ordinances that do not allow people to use the word notario or notary because they find it misleading to the public. So be mindful of that and be careful with who you hire to do paperwork if you're not hiring an immigration attorney. Um, Thank you for that question. That was a live one. Okay, another question we got is if I entered the country illegally, do I have any options or is there really nothing to do? So let's talk about that. This is a really big misconception that I hear. Entering without inspection, which is what we call when people cross the border or don't have a visa, it does not automatically mean you have no options. If you have a qualifying US citizen or a lawful permanent resident family member, a spouse, a parent, or a child, there may be a path. I say may because at the end of the day, it does exist. Every case is different, and some people qualify and some don't. But the answer is almost never there's nothing to do. There is a waiver. In Spanish, we call it un perdón. It's called the I-601A waiver. And that waiver specifically exists for people who entered without inspection and without a visa and have what we call a qualifying relative who would suffer extreme hardship if they were to leave the country. So, what does that mean? Immigration doesn't care if you suffer because you are not here lawfully. They care if the US citizens and lawful permanent residents around you are going to suffer if you are deported. So, that's what the waiver is based on. We have to show that they would suffer if you weren't here helping them, providing for them, caring for them, etc. So, what matters is what happened, when it happened, and what family ties you have in the US. And that analysis is what a consultation is for to determine if you do or don't qualify for a waiver. But don't assume that there's never anything to do if you entered illegally because the answer is no before you've talked to someone. So, very important that you talk to someone. Um, I have another interesting question here in my Q&A. Somebody received a document that says they have to go to a master hearing and they want to know what is a master hearing. So the document they received is probably what we call an NTA, which is a notice to appear, NTA for short. And a notice to appear it's almost like a ticket that says you've been placed in removal proceedings. It is a charging document. I call it a ticket because when you get stopped by the police and you get handed a ticket that makes you go to court, it has a similar effect. Now, this is a much bigger deal than getting a regular traffic ticket, but the document has the same effect. It is what initiates proceedings in front of a court and requires you to appear in front of an immigration judge. And that process has two main stages. So there are master hearings and there are individual hearings. So this person is asking, what is a master hearing, which is what they've been set for. The master hearing, a master calendar hearing is what we call it, is like a first hearing. Think of it as an administrative stage or like calendar call if you're familiar with other courts. The judge will confirm who you are. They will confirm the charges that are alleged against you. They will ask you whether you're contesting removal, and usually they will ask you what you are applying for if you're applying for a defense. And usually it's pretty short. Sometimes it's even under 15 minutes. You might be there for a while waiting for them to call your name, but the hearing itself is pretty short. But don't let that fool you. What happens at a master calendar sets up everything that comes afterwards. The individual hearing, which is different, is your trial. So you may have more than one master. Most people will have at least one. After that, your individual hearing is your actual trial. This is where you present your case, your testimony, your witnesses, your evidence, and it's where the judge will actually decide whether you get to stay or whether you're ordered deported. And that can last several hours, sometimes a whole day, depending on your case and your particular matter. And here's what people don't realize. You can waive rights at a master calendar hearing without understanding what you're giving up. At your first master, the judge does go through all of your rights, and we've seen many people show up without an attorney and agree to things that hurt them at the individual hearing later on. So if you have an NTA, even if your first hearing is months away, you really should seek representation or at least seek some legal advice. And the preparation for your individual hearing really starts at your master hearing. So if someone you know or someone you love or yourself have received an NTA, don't walk into that courtroom without some advice. You really should get a consultation so we can determine what your defense is going to be, what you're going to do about it, etc. So really important that you not ignore that. And if you don't go to your hearing, you will be ordered deported in absentia, is what they call it, which is when you don't show up for a hearing, so you automatically get ordered deported. So super important that you not do that as well. All right. Next question I have here is, let's see. So I already have, this person already has a deportation order and they want to know, since their case is order over and they already have an order, is there anything they can do now about it? It says they were deported a while back and they want to know, is there even an option for them now? Okay, so let's talk about it. This is actually a really important question. And the answer is we almost always can find something, but it depends. And it is rarely truly over. I say that because a final order of removal, it is serious. It does mean you have a deportation order. But there are some legal mechanisms that exist specifically for this type of situation. There's something called a motion to reopen. There's another thing called a motion to reconsider. There's something called a stay of removal. There are appeals that can be done to the Board of Immigration Appeals, and there are even federal cases. So there are a lot of mechanisms that still exist after a deportation order has been given. And whether you qualify for them or not is really fact specific to your case. So we do need to get into the nitty-gritty to determine if you can do any of these. When we talk about a motion to reopen, which is generally the most common one, it asks the court to re-examine your case. Essentially, we're filing a motion with the judge telling them something has changed, there's new evidence, there's a change in the law, something went wrong, my old attorney made some mistakes, or there are some new legal arguments, there's been something that has changed recently, and those things are giving you the opportunity to try again, and you're asking the judge almost to have mercy on you and reopen that case because there is some argument that wasn't there before or that is a newly formed argument that could reopen your case and you can try again. Now, timing matters here enormously. Some deadlines are very short. Sometimes we're talking about 30 days within the deportation order. Some timelines have exceptions. For example, if you didn't know you were deported and you didn't get proper notice, we might be able to file motions to reopen years later. We've done it many times successfully. There's also something called a sua sponte motion to reopen, which is when we ask the judge to reopen on almost discretionary grounds. And we can reopen cases years later, depending on the circumstances. But the truth is, the longer you wait, the fewer options you have. So if you're someone who does have a removal order, it behooves you to try to deal with it as soon as possible. And if you have a final order and you are still in the United States, I would strongly urge you to come talk to us before anything else happens. We have filed many motions to reopen in our office that have given families years of additional time and sometimes a path forward. So a final order is not always the final word, but you need to move as quickly as possible. And that's a conversation you need to have as soon as possible with legal counsel. Whether that be me, whether that be my office, or whether that be anyone, make sure you get yourself some good advice. So, all right, let me see some other questions here. Okay, we have a question about this person is applying for a marriage-based green card application and wants to know about the how to prepare for the interview. And they note that they've heard about people getting separated. And how does that work and what to do? Okay, so let's talk generally about the process. For marriage-based cases, The green card interview or the residency interview is where USCIS finally calls you in to an interview. And when that happens, you sit across from the officer, often with your spouse, and that officer gets to decide whether they think your marriage is real, and whether you qualify for the benefit that you're actually seeking. That's the interview. It generally happens in an office with a USCIS officer. The officer goes through your whole application, verifies your documents, asks questions about your relationship. Sometimes they interview both spouses together. Usually they interview both spouses together. Sometimes about your relationships, sometimes about your daily routines, sometimes about your household, sometimes about your finances, your families, etc. And what trips people up generally at these interviews really isn't lying, because, most couples are real. They go in there and it's not that they're lying about who they are or their marriage. Really, it's about inconsistency. Oftentimes we have two people who are genuinely married and give different answers to different questions when they're under pressure. Nervousness looks like deception or can look like deception to an officer, and gaps in your record look like red flags. And so, really, this is about preparation. You really need to know your file inside and out. You need to know your dates inside and out. You need to understand what the officer is looking for. You need to walk in with organized, complete documentation that really documents your relationship clearly, that tells the story of your relationship clearly. And it's really important that you prepare for this interview. In our office, we do interview prep for all of our clients. We really try to make it not optional. We try to build it in. The interview is really important. It's really too important to walk into really cold. So I'd highly advise that you prepare for that interview. And like I said, real couples, which is who we represent, often do terrible at these interviews because they're not thinking about what color their shower curtains are or what color their bed sheets are, and we have countless examples I can give in this office of questions they have been asked where their answers didn't match when they were separated, when the couple was separated. For example, I specifically remember a client that was asked what they had for dinner the night before. And the husband in this case said it was soup, pizza, and tres leche dessert. And the wife said they had just had pizza. She didn't say just, she just said we had pizza. And to me, that's not a conflict, right? They both said pizza. But because the husband said soup and dessert, the officer felt that the wife who just said pizza really either just didn't disclose all of it, and they felt that was an inconsistency. They actually thought that's not a match in the answer. So again, it's not about lying. It's about your answers matching and about trying to avoid inconsistencies. So I'd highly advise that you prepare for that. Do everything you can to get familiar with the types of questions that they ask. And, um, we do interview preparation in our office if you're interested, but again, it doesn't have to be with us. Do it with anyone, but make sure you get some good advice. Make sure you get some prep before you walk into that interview. The other really important part about that interview is taking in all the documentation. The officers are expecting you to bring documentation to that interview to show proof of your marriage. And when we talk about documentation for your marriage, we're talking about bank statements, we're talking about credit card statements. And some people don't have all that financial evidence. There are other examples of things that you can show. We have gotten really creative. We have shown joint gym memberships. We have shown veterinary bills to show that the vet has both your names as parents of the dog. We we have shown applications for citizenship in other countries. We've even gone as far as showing, Facebook posts announcing certain things as a couple, or we have shown um, memberships together at country clubs. So you can get really creative with the type of evidence that you can show an officer. Obviously, they like the financial stuff most. They like to see your joint tax returns. They like to see your joint credit cards. They like to see joint health insurance, joint car insurance, joint life insurance. These are the things they want to see. But it's not required. You can get around it by showing some other stuff. So I think I've answered all the live questions. So if anyone out there, I see a bunch of you on here. If you want to ask a question, please don't forget to use that Q&A button and just go ahead and throw it out there. In the meantime, I'm going to go to some of the questions we got ahead of time. So just looking at that list, we had another question that was, Can I work while my immigration case is pending? That's a really, really common question we get, so I was glad someone asked about it. This particular person was an asylee, was a pending asylum, but I'm going to answer it more generally than that. The answer to can you work really depends on where you are in the process, what process you are doing, and it's really one of the most important practical questions you can ask. If you filed a green card application, an adjustment of status, that's what it's called, meaning you're applying for a green card while you're inside the United States. We're not talking about consular people. You can also generally file for an employment authorization document, which we call an EAD for short. And once approved, you can work here legally. That doesn't generally have restrictions. That may be different for some business-based cases, but when we talk about general adjustment of status, there's um, not usually a lot of restrictions for who you can work for, what company you can work for, and it is renewable while your case is pending. Okay. Now, EAD processing times have improved, but they can take several months. Um, there are some circumstances where they move faster, some move slower, and I wish I could tell you there's some science to this, but I'm convinced immigration throws these things up in the air and randomly selects them. I have some people approved real fast, and I have some people who are not. So, really, there's not tons you can do to make it go any faster. But yeah, it is a possibility for you to work while your case is pending, depending on the type of case. Similar in asylum, there are pending applications you can file for work permit if you're an asylee. Now, if you are in court, if you are in removal proceedings, that's a little more complicated. Work authorization or an EAD, as we said, could still be available depending on what you are applying for in court. Um, and yeah, but working unlawfully could be used against you. It could be used on the side of discretion. So don't assume. Ask before you start working. Make sure you get some advice. Work authorization is something we map out for every client from day one because I know it's one of the biggest concerns of people that come to us, and you shouldn't have to guess whether you're allowed to support your family or not. So that's really important for you to understand as part of the bigger process that you are doing. So short answer, it depends. It depends on the process you're in. It depends what part of the process you're in. And it's very fact specific to the type of case. So make sure you are asking that question depending on what specifically you are applying for. Great. So I mentioned okay, so somebody asked a question here about translations, live question. And this person is saying they need to get their birth certificate translated, and what does an immigration officer require in order to accept the translation? So it's a good question. It's a very practical question. So, to get your birth certificate translated, you can do it anywhere. You can do it by anyone. You don't need to do anything formal. It doesn't need to go to a former interpreter. It doesn't need to go to a formal translator. However, I would recommend using one because we have seen mistakes that have caused really big hiccups in cases. For example, we had someone who used a family member actually to translate their birth certificate. And then the second part of this question, what do they require in order to accept it? It does have to come with a formal sworn affidavit that they are competent to translate in both languages and that this is a true and correct translation to the best of their ability. There's some really specific language that should be at the end of this. And you could technically Google it, try to do it yourself. I highly don't recommend it. Again, just like I recommend using an attorney, for legal things, I recommend using a formal translation and interpretation service if you can for these documents. And I was about to tell you a story. Let me make sure I do that. So we had a case of a man who was actually a Ukrainian citizen, and his birth certificate was it was Ukrainian birth certificate, but it was during certain points of the year when there was some Russian language on the Ukrainian birth certificate. He was born during a specific governmental period where there was an issue there. And anyways, the long and short of it is he had it translated by someone and they did a decent job, but they actually put a typo in his name. When I say typo, I mean they translated an I as a Y or something like that. Yeah, it was an I and a Y that they translated differently, or a Y and a G, something like that. And so the translation didn't match any of his other translations. In other words, his passport, his visa, every way that he had translated his name to English from the Russian alphabet did not match this translation. And it wasn't caught. He submitted it directly. This was before they came to hire us. And instantly we got what they call a request for evidence from USCIS. And this is when he came to see us. A request for evidence basically is a delay in your application where the government asks you to clarify something. So it delayed his application. More importantly, it actually called into question the officer that he got went as far as saying that he wasn't sure he was who he said he was and wanted him to prove that this was the same document, like the person that applied before is the same person that's applying now. And they were actually questioning his identity because of the document submitted, which seems absurd for a typo, but this is a great example of immigration making a mountain out of a molehill and how one letter could really mess up an entire process. So hence why I highly recommend that you get yourself an interpretation service or get yourself a former interpreter and translator company that is certified and stands behind their work because a small issue like that could be a big deal. Now, um, yeah, especially if it's a language you don't understand or a language that the officer may not understand, or for example, like the Russian alphabet, that's completely different, the Arabic alphabet. So if you're dealing with a language that is not easily verifiable by your attorney, by whoever is reading these papers, it's really, really important that you get this done in a good place that stands behind their work. So I hope I answered that question. Again, it does require a official certification. And technically anybody can do it, but just be really mindful of mistakes. No different than, again, trying to do the paperwork yourself without an attorney. So, yeah. All right, let's keep going. I have another question here about interesting. Okay. I have a question here about fiance visas. Why would I ever do a fiance visa instead of just getting married and applying for a green card? So let's talk about that. This is a really interesting question that we answer quite a lot for people who are not yet married that come see us in the office. Essentially, a fiance visa, which is K1, is what we call it, K1 visa. A K1 visa allows a US citizen to bring in a foreign national fiance into the United States to get married here. You have 90 days to marry once they enter. So the key difference of why you may want to do this instead of doing a green card directly is actually the standard of proof. And by that, what I mean is it is easier to get approved for a fiance visa than it is to get approved for a marriage-based green card. And if you think about it, that really does make sense because the excuse me, fiancés have not yet started to build that life together. So immigration doesn't require as much paperwork. You don't have to have commingled your finances yet. You don't technically have to be living together yet. And so the standard of proof for what you have to show you're really fiancés is actually much lower and a lot less evidence than what you would have to show if you were trying to show that you were really married. You need to show you have a bona fide intent to get married and not just, not years of shared life, which is usually what you show for the marriage-based application. So it's much easier. But just note that if you do bring someone in with a fiance visa and you get them into the country and then you marry within the 90 days, you still need to file that green card application. Like the next step will be filing the green card application, and USCIS will look at the full picture at that point. So you really can't shortcut your way through trying to prove a real relationship, but it does gain you time, and it makes it easier. K1s are great. Fiance visas are great when the couple is abroad and they want to be in the US eventually. It's great for people who haven't quite figured out if they're sure they want to marry someone, or maybe they have the intent to marry someone, but they want to give their relationship a little more time to progress. And, the fiance visas take a while. So it really gives you time, it gives you energy, to deal with your relationship and really decide eventually, once the date comes, that yes, we're going forward, everything is good. It's not automatically better or faster than consular processing a marriage-based card, but it really just depends on the couple situation. If you are married or you're going to be married for sure and you've already commingled all your documents and this is a done deal, then, maybe skip the fiance visa and go straight to a green card application. But if you're not sure or you don't have a lot of documents or it's, hard to prove right now because you're not living together, you're separated abroad, you're cross borders, as I always say, the fiance visa could be a really, really good option for people. So the right path really depends on where you are, on your relationship timeline, on your individual circumstances. And one conversation can really tell you what road makes the most sense. So, again, I'd encourage you to book a consultation, talk to your significant other, and kind of feel out what makes the most sense for you. So, all right. Someone heard me earlier mention an I-601A waiver and is asking, how does that work? And who qualifies. Okay, so let's talk about that. An I-601A waiver is called a provisional unlawful presence waiver. That's the formal name. And it's for people who entered without inspection or who overstayed and have accumulated unlawful presence in the US. So what does that mean? That means they either entered through the border or they entered with a visa and then they stayed past the time of their visa. So they've essentially been illegally in the US, they've been unlawfully in the US, or they entered without inspection initially, which is when people come through the border or and usually didn't get caught. Sometimes it is for people who got caught. That's not really what makes the qualifier, but generally people who entered without inspection. So which normally when you unlawfully stay, let's go back to that one, you will trigger a bar. What does that mean? It means you will trigger a punishment when you leave the United States. So once you leave the United States, you will either have a 3-year or a 10-year punishment to return because of your time unlawfully in the US. And that's depending, the 3 or 10 depends on how long you were unlawfully in the US. So what's this waiver and how does it make it all go away? Essentially, we don't use the word pardon in immigration, but it's essentially like a pardon. And in Spanish, people call it el perdón, which is very similar. So to qualify for this waiver, you must have a U.S. citizen or a lawful permanent resident spouse or a parent. So a parent or a spouse that is a U.S. citizen or lawful permanent resident. And we call that a qualifying relative. Your child does not account for this waiver, unfortunately. I wish he or she did, but children cannot be used as the qualifying relative for the waiver. So that makes it a little tougher. And so you have to show that your qualifying relative would suffer extreme hardship. And I did mention this earlier in the seminar, the standard of extreme hardship. It is a legal standard. It is higher than it would be hard if we were separated. It is much higher than that. It is an extreme hardship. So we have to show that if you are separated or if they had to leave without you, I'm sorry, they had to leave with you, that it would be very, very difficult. It would be extreme hardship. And what counts as extreme hardship? Medical conditions count often as extreme hardship. Financial devastation counts as extreme hardship. If you have children with special needs that require caretaking of a spouse or a parent, if you have parents who are aging and need your care, if there's career impact to your spouse, all of these things are examples of things that could be extreme hardship. We can get very creative and think about outside the box as to what is extreme hardship. But no matter what we're arguing, it has to be documented, it has to be argued. It is an argument that's made on paper through a legal brief. Just submitting a bunch of papers, I've seen that done by a lot of people representing themselves. Not a good idea. That is never enough. Highly recommend a brief that spells out for the officer all of the reasons that there is sufficient hardship. And if you file that and if you get approved, then you leave to go to your consular interview. So that is the amazing part of the I-601A, is that it's like the reason we call it provisional waiver is because you can pre-file it before you have to leave the country. And that makes a huge difference because you're leaving with a pre-clearance. Your bar is essentially forgiven in advance. Your punishment is forgiven in advance. And so it's a much better position it puts you in when you go to that consular interview. Now, the denial rates are significant for cases that are poorly prepared. The hardship argument really is everything. And, the overall percentage of cases, last I checked, was about 60% that get approved. So, and that was pre-Trump administration, so it's probably a little lower now. But I will say that in our office, we have an amazing rate, and I can't promise that we always will, but we have an amazing approval rate because a well-prepared case in this with this type of case really makes a huge difference. So I often tell people if they can't afford an attorney for the petition and they can't afford an attorney for some of the paperwork, this is one of those things that you would scrape together your money and spend it on, because I would absolutely not recommend anyone take their own waiver into their own hands. It is really hard to make these legal arguments in an effective enough way. And almost all of the denials we see here in our office are people coming back to us because they tried to do it alone, or they used someone who wasn't an attorney, and we had to actually do a new waiver or start all over, or try to respond to a request for evidence because it was too weak what they sent in or they didn't do it properly. So this is a really high stakes filing. They also take anywhere from 3 to 4 years to adjudicate. So think about it. Think about how you're doing this on your own and then denied after 3 years, you have to start all over. You're going to lose another 3 to 4 years. So definitely recommend that you not skimp on this one and take it really, really serious. All right. I got another live question here. So somebody asked, if something goes wrong during the interview, how long will it take to get another interview? Or is the case going to be denied or dismissed, or what happens? So it really depends on the officer that's interviewing you. So for I assume we're talking about marriage-based green card. Maybe we're not. It really depends on the type of case. If we're talking about a marriage-based case, generally you will get a second interview, and that's what we call a Stokes interview or a separation interview. And that's when you come in for your first interview and something went wrong. The officer didn't quite believe your marriage or wasn't really satisfied with the paperwork. And from there, what they do is that they will separate you into two different rooms. They'll give you a second interview where they'll separate you, and then they ask you questions to see if your answers match. And that's the example I gave earlier about the pizza and the soup and all that. That's when we're talking about marriage-based. Generally, it will come with a second interview. That interview is even more high stakes. I highly recommend you get legal counsel for that interview to accompany you and prepare you. That being said, can they just dismiss your case without a second interview? They can't. The officer doesn't have to give you a second interview. They can just deny your case. They can approve your case too, frankly. They do have the discretion to make a decision with just the one interview. Now, that being said, moving forward, let's assume this question is not about marriage-based cases. If this question is not about marriage-based cases and we're talking generally about an interview, for example, related to a regular adjustment case based on, let's say, Cuban adjustment or based on VAWA, which is the Violence Against Women Act, will they get another interview? Really depends on the officer. We have seen cases approved with no interview. We have seen cases approved with some interviews. We have seen cases approved with multiple interviews. It really, really depends on the officer that you have, and it really depends on what they want to see and what they want to ask you. So it is very, very case specific. Other than documenting your case really well from the get-go, there's not much you can do to avoid an interview in the first place. So just a heads up on that. Okay, let's keep going. The next question, we have about 11 minutes left, so if you have any more live questions, I do see some still in there. I'm trying my best to get through all of them. I don't think I'm going to get through all of them, so I'm sorry about that. But I would encourage you to reach out to our office. So let's see here. Okay, so my next question I have here is about someone who their spouse has a criminal record and they want to know if it's worth applying or if that automatically disqualifies them. Now, the question is an interesting one because it really depends on what we're applying for, which this person didn't clarify what they're applying for. But the short answer is no, not automatically. But it does matter what you're applying for. It matters what the record is, more importantly. So what I mean by that is there's a big difference between a DUI, like driving while drunk, or a drug offense, or a domestic violence conviction, or what we call an aggravated felony. The immigration consequences of each of those are totally different. and what you qualify, what you don't qualify, whether or not you can do a waiver or perdón in Spanish, really depends on the specific law under which you were convicted, really depends on if you were convicted. Some people were arrested but not convicted. Some cases look worse than they are. And when we start looking at the case law, it's actually not that serious. Some cases look really minor but end up being quite devastating. So just reading what it is and being like, oh, that doesn't sound like a big deal, is not a good way to go about it. This is one of the most dangerous areas, in my opinion, to take a guess on. I've seen many people denied because their attorney didn't flag, some 15-year-old misdemeanor that nobody thought was a big deal. I paid my fine, I did my time, all is well in the world. Unfortunately, that's not how immigration works. They won't relitigate the case, but they absolutely will look at it. It absolutely matters. This is especially true when we talk about marijuana convictions, which, what happens with a marijuana conviction, a marijuana possession conviction varies greatly from county to county and state to state. But ultimately, the most important thing, and if you follow us on socials or you follow our newsletter, you might have seen us recently posting about marijuana. Yesterday was 420, so in honor of marijuana, we actually did some interesting articles if you want to go check out our blog. But the reason it's so important in the immigration world is marijuana is still a controlled substance that is completely illegal on a federal level. So many of you watching may live in states where it's been legalized. That's true. The state has legalized it, but it is not legal federally. And so we have a lot of clients who get themselves in trouble by using marijuana when they're not supposed to, by taking jobs at dispensaries. Think about it. If you are working at a dispensary and you're not a citizen of the United States, you could be accused, even if you're a lawful permanent resident, you could be accused of trafficking. I know that sounds crazy, but you could be accused of cultivating marijuana, like growing it. You could be accused of trafficking it because you're selling it. And that doesn't sound logical because you're working a regular job for someone else at a counter. But because marijuana is completely illegal still at a federal level, that is possible. And we do see that happen. So stay away from pot if you are not a citizen of the United States. But nevertheless, I only bring that up in the bigger context of having a criminal record. That is, unlawful drugs are particularly complex because there are some drugs that are okay under the law in some places, in some counties, in some states, and not in others. But even outside of talking about drug matters, like I said, there's a difference between a DUI and a domestic violence conviction. There's a difference between an arrest and a conviction. Sometimes you are arrested, but you're not convicted. Sometimes you fought the charge, sometimes you didn't. There's a lot of different things that could sound like you didn't get a conviction, but you were. So it really, really depends. And if you have anyone or you personally have a record on your case, your spouse's case, even an arrest with no conviction, it really needs to be on the table at the consultation with an attorney before you file anything. That's also true of citizenship, especially true of citizenship. If it happened within the last 5 years, it's going to be up to the officer. They're going to look at it. And sometimes we can make a good argument for why it shouldn't be used against you, and sometimes we can't. And that's really circumstance specific to what the case is. So I highly, highly encourage you to get a consultation. But to your question of does that automatically disqualify you? No, technically it doesn't. It just means you have to do a slightly better job than most in getting informed. So. I think I'm going to pause there. We've covered a lot today. And to be honest, we've only scratched the surface. There are so many things in current events happening that there's no way we could get to all of it. But thank you so much for all of your questions. We really got some great questions. And I do see there in my box that we have several more. Sorry, I could not get to all of them. But to everybody watching, everyone has a different story, a different timeline, different facts. And that's why there's really no substitute to sitting down with someone who can look at your case specifically. I'm always hearing about, my brother, my sister, my cousin, my uncle, my neighbor got this and that, and their attorney did this, and every case is truly different. I can give you general information and I can continue to answer your questions. I'm always happy to do that. But at the end of the day, if we talked about anything that sounded like your situation or like the situation of someone you love, please give us a call. Again, my number is right here. You can book a consultation with our office. And like I promised at the beginning, because you showed up today, because you took the time to get informed, to get involved, to ask questions, to seek advice, I mentioned that I would give you something. And basically, if you mention that you attended this webinar, when you call our office, you will get a 50% off your consultation fee. So we're going to give everyone who's watching right now 50% off on their consultation fee if they decide to give us a call and book that. Technically, it is after hours. We do have live answering service. You can leave a message if you like, or you can give us a call tomorrow. Either way, whatever's easier, or you can go right onto our website and get all of our information as well. We are physically located, like I said, the office is in Miami, Florida, but we do have cases absolutely everywhere nationwide. We all travel in this office for cases, and a huge percentage of our cases are in New York, Chicago, Philadelphia, Charlotte, Atlanta, kind of all over the US, and all the immigration courts. And that is our specialty. So please give us a call. We're happy to set up a Zoom. We're happy to do it on the phone, et cetera, et cetera. This is a sales tactic. It's me rewarding you for doing exactly what you should do, which is getting informed. So if you're interested, please take advantage of that and give us a call. All right, so I'm gonna drop let me see if I can make this chat work. No, I can't. Okay, so we're good. I don't have to drop anything because my number is right here. So make sure you write it down. It is 305-916-4800. That's our number. Our team picks up fast. Again, you can also leave a message after hours and, come talk to us. Again, my name is Elina Santana. You can see my name at the bottom of the Zoom as well. And I thank you wholeheartedly for coming today. And I thank you wholeheartedly for sticking around, asking questions, and participating. So thank you. In 2 minutes, we will start this webinar all over again, but we'll be doing it in Spanish. So if you want to stick around, you're welcome to stick around. If you have family or friends that would like to join in Spanish, again, some of the questions are going to be the same because they were written into us ahead of time. Some of the questions are not because we also took a ton of live questions while I've been here. So feel free to stick around if you want to for the Spanish one, but if not, feel free to log off, and I wish you a wonderful evening.